Welcome to this channel. In this session, we will discuss the difference between the fundamental rights, constitutional rights, and legal rights. Let us start now. The fundamental rights are enshrined in the Part 3 of the Constitution. Fundamental rights are the basic freedom guaranteed under the Constitution from Article 12 to 35. There are 6 fundamental rights, such as right to equality, freedom of religion, right against exploitation, right to life and liberty, and others, which are the basic rights which cannot be separated. Fundamental rights cannot be curtailed. Fundamental rights comes under the Constitution. So we can say fundamental rights are constitutional rights. But constitutional rights are not fundamental rights, because in Constitution there are other sorts of rights given to the citizens. Neither the Parliament nor the citizen can separate or waive or abridge the fundamental right. If there is an infringement or violation of the fundamental right, the aggrieved party can move to the Supreme Court directly under Article 32. The person whose fundamental right has been infringed can apply to the High Court and Supreme Court through the writs. Supreme Court held that right to privacy is a fundamental right. But fundamental rights are not absolute, but under reasonable restrictions. Fundamental rights are one sort of natural rights guaranteed by the Constitution. Constitutional rights. On the other hand, constitutional rights are those rights which are given under the Constitution apart from the fundamental rights, where fundamental rights is applicable to all. Not so in case of the constitutional rights. It is not to the basic right. The union and state government can enact law, and if such law violate the constitutional rights, then such law will be declared null and void. The constitutional rights is not applicable to all. Say, right to vote is a constitutional right given to the person above 18 years of age. So the person who is below 18 years of age cannot cast vote. So constitutional right is not applicable to him who is below 18 years of age. If the constitutional rights are infringed or violated of any person, then such person can move before the High Court under Article 226 for the enforcement of the same. As earlier stated, that in case of fundamental right, one whose right has been infringed or violated can directly move the writ petition under Article 32 before the Supreme Court. But not so in case of the constitutional right. It should be initiated from the High Court. Though the constitutional rights are called the supreme rights, but it can be taken away in the proper legal procedure. Legal rights. Legal rights are known as the ordinary rights, derived from the statutory law. It is neither the absolute rights nor permanent rights. Such laws are enacted by the union and state legislature for the particular purpose or for the particular section of people, such as Contract Act, Transfer of Property Act, Easement Act, Partnership Act, and the laws of this act is operative to those whose actions are guided by the or under this statute. Another example is right to vote is a constitutional right, but the Representation of the People's Act deals with the election procedure and the person who are contesting the election. So, if there is a conflict or violation under this act, the aggrieved person or aggrieved party can move against the state or the individual before the lower court or district court under the laws of the said act. There cannot be any statutory law which goes against the principle and provisions of the Constitution. It is an ordinary right. The aggrieved party can sue against the state or the individual, but in case of the fundamental rights, the aggrieved party must file the suit before the Supreme Court. And in case of the constitutional right, the initiation of the case or suit from the High Court. As fundamental right cannot be abridged or waived by the state or the citizen, but not so in case of the legal rights. The state may repeal the act and individual may waive the rights under the act. Say under the tenancy law, the landlord have every right to evict the tenant after the expiry of the tenancy period. This right is the ordinary right or legal right of the landlord. The landlord may impose the right or may waive the right. It is up to him.